Thank you so much for joining us today for our webinar, The Philippines, the ICC, and the Fight for Accountability. My name is Nour Nassif. I'm the Hague representative with the Coalition for the ICC. You should have all received the agenda for today, but I will drop it in the chat in a bit just in case. So in today's discussions, we will examine the ongoing case against former Philippine President Rodrigo Duterte at the ICC. We will dive into three primary discussion points, looking at the current situation, challenges and opportunities, also looking at what does a victim-centered approach to the Duterte case mean, what role can grassroots movements play, and what challenges do human rights defenders face in the Philippines and abroad. You'll hear from ICC officials, legal experts, human rights advocates, and Filipino community voices as they explore what this means for justice in the Philippines and its impact on global efforts to end impunity. But before we begin, just a few quick housekeeping notes from our side. So as I mentioned, we will have 3 sessions where our panelists will intervene on the aforementioned topics, followed by a Q&A. So please feel free to submit your questions anytime using the Q&A option below, and we'll address as many as we can at the end. And this session is also being recorded, so it will be available to watch later. And you will also find interpretation below. We're providing interpretation from English to Tagalog. The interpretation may say French, but it is actually not. Zoom doesn't allow us to change the language. I will now quickly introduce our panelists for today before handing it over to my co-host, Dr. Aurora. We have Chantal Daniels joining as the International Cooperation Advisor at the Office of the Prosecutor at the ICC. We have Attorney Joel Butuyan joining from as part of the Philippines Coalition for the ICC. We have Professor Nimia Pimentel, part of the Philippines Coalition for the ICC, but also the Alliance of Human Rights Advocates, the Philippine Alliance for Human Rights Advocates. We have Maria Julia Cerdas, Associate Officer for the Victims Participation Reparations Section at the ICC. We have Francisca Eckelmans, Legal Advisor at the Trust Fund for Victims at the ICC. We have Benji Aquino, Legal Assistant at Redress. Dania Chekel, FIDH representative to the ICC, Colleen Arcaña, Executive Director for the Ateneo Human Rights Center and also member of the Philippines CICC, and Attorney Gilbert Andres, Executive Director of Center Law for the Philippines and member of PCICC as well. So I will now hand it over to my co-host, Dr. Aurora. The floor is yours.
Thank you, Noor. Hello, everyone. I'm the Aurora, and I co-chair the Philippine Coalition for the International Criminal Court. On behalf of the PCICC, I welcome you all to this seminar. Thanks to CICC for organizing this, and all our speakers who will help us dissect the issues related to the Duterte case at the ICC. And hopefully, we will understand the situation better, as well as understand also what the situations of the victims and their families are. In the Philippines and at the court, former President Duterte, who ordered the killings of about 30,000 as part of his bloody war on drugs, is being painted or described as a fatherly gentleman and fragile former president while he is in detention in The Hague. Such misinformation aggravates the sufferings of the already traumatized victims and families while seeking justice at the ICC. For most victims and their families, hope for justice lies at the ICC. This is because the Philippine justice system has only made accountable 9 policemen for killing and torture of 6 people out of more than 6,000 killed in police operations. Though Rodrigo Duterte is in detention in The Hague now, his co-perpetrators in the crimes against humanity and many of those who directly killed, tortured, and committed sexual abuse are still scot-free. So we hope that we can all better understand the challenges and opportunities and later take action at the ICC very soon. Thank you. I am moderating the first session. So in the first session, we'll have Chantal Daniels, who is the International Cooperation Advisor at the Office of the Prosecutor of the ICC. She is based in The Hague. And the next will be Joel Butuyan, who is a Philippine-based lawyer, president of Center Law, and currently assisting victims and their families in presenting views and comments of families to the International Criminal Court. He's also an ICC accredited legal counsel. Center Law is a member of PCICC. And we also have Nimia Simbulan in the panel. She's currently chairperson of the Alliance of Human Rights Advocates and also executive director of Field Rights, an organization which is documenting violations of the war on drugs. To start, maybe I will call on Chantal. Could you briefly explain the court's mandate and jurisdiction, particularly in relation to the crimes against humanity, and how the Office of the Prosecutor determined that the alleged crimes under the Duterte administration fall within this jurisdiction? Thank you.
And thank you very much, Aurora. And thank you so much. Good morning and good afternoon to all of you. It's a great honor and pleasure to be with you all today. I'm sorry that it's not in person as originally foreseen, but unfortunately due to the postponement of the confirmation of charges hearing, it's online, but it's still a great pleasure to be with you all today. I'll try to keep it as brief as possible to allow for more discussion, but just very generally, some of you will already be aware of this, others may have a little bit less of a background, but as Office of the Prosecutor, our mandate with regard to the Philippines is a limited mandate. We're only authorized to investigate crimes that have been committed since the 1st of January 2011 until the 16th of March 2019. And the reason why this mandate is more limited and it doesn't extend until today or doesn't go back before is because the Philippines only ratified the Rome Statute and it took entry in on the 1st of November 2011. So that's the start date from which the Office of the Prosecutor or the ICC can actually investigate and prosecute cases. And just shortly after we as Office of the Prosecutor started determining whether to open up an investigation or not, the Philippines authorities decided to withdraw from the Rome Statute. So that is the end date, and actually the withdrawal took effect on the 16th of March 2019. So the Philippines used to be a member of the Rome Statute, used to be a member of the ICC, but currently is not a member of the ICC anymore. As Office of the Prosecutor and as ICC, we, however, determined that the crimes that were committed during the time that the Philippines was a member of the ICC would still be within our jurisdiction, so within our mandate to investigate. So it's in that context that we have been investigating war on drugs crimes that were committed during this specific period. And earlier this year, and let's be honest, it's an unprecedented year, because if we would have had a similar meeting last year, no one would have ever expected that we would currently be having a former president in detention, facing at least a confirmation of charges hearing. But throughout our investigations, we've collected evidence, we've taken statements from victims, from alleged perpetrators, we've been compiling videos, doing analysis of police reports, we've collected an awful lot of information from a lot of you, the civil society organizations, the NGOs on the ground who have really been at the heart of the work that we've been doing in the Philippines, especially without us having a formal line of communication with the Philippine authorities. So you've really been our eyes and our ears and actually partly our arm to a lot of the families on the ground. And I really want to acknowledge that here, because without you, there would have not been a Duterte case and there would have not been a Philippines case. But based on all of the work that we've done, together with some of you and together with a lot of other countries and their support, we submitted an arrest warrant application for former President Duterte earlier in the year to the judges of the pre-trial chamber. who issued the arrest warrant on the 7th of March, and subsequently the Philippine authorities arrested and transferred former President Duterte to the custody of the ICC on the 12th of March. He immediately afterwards had his first appearance, and the judges set specific deadlines for us as Office of the Prosecutor, but also for the legal representatives of victims, as well as for the defense, and especially for us as Office of the Prosecutor. Between a first appearance and the confirmation of charges hearing, which was supposed to take place tomorrow, there was only 6 months for us to actually continue collecting the necessary evidence to fill evidentiary gaps, to work on witness protection, to disclose information that we actually relied upon in our investigations to the defense and to other parties to the proceedings, and to prepare necessary documentation, such as the document containing the charges, on which I know that everyone is waiting for a publicly redacted version, and we very much hope that that is coming soon. But also the pre-confirmation brief. So actually in the 6 months between the arrest and now, what we have really been doing is making sure that we fulfill all of our obligations as Office of the Prosecutor in the disclosure of information to all parties to the proceedings, in preparing the document containing the charges, in preparing the pre-confirmation brief, but also really trying to fill evidentiary gaps, trying to see how we can actually reinforce some of the allegations that we have for the confirmation of charges hearing, but also really work on making sure that our protection obligations are being fulfilled, that the witnesses that we're working with are in a safe location and do have measures to protect themselves. And then, of course, I do really want to emphasize that the confirmation of charges hearing is not yet the trial. It's really the moment that we're preparing for, to show what kind of crimes we allege Mr. Duterte of, and then hope that the judges agree with us to subsequently commit Mr. Duterte to trial. Does that mean that our work is over? Absolutely not. At this moment, of course, we as Office of the Prosecutor are ready for the confirmation of charges hearing. We're really hoping that this hearing is going to take place as soon as possible, but that currently lies with the judges of the ICC. What you see is that there is a lot of litigation going back and forth between us as Office of the Prosecutor, between the defense, the judges. This is, of course, a really normal procedure in front of judges, but I can imagine that it causes a lot of unrest, a lot of questions, whether it's about jurisdiction, whether it's about interim release, whether it's about the medical condition of Mr. Duterte. Unfortunately, a lot of these questions we cannot answer at this moment because a lot of this is actually in confidential filings. The judges have not yet pronounced themselves over some of these issues, but what I can reassure you is that at least, and I can imagine that the same counts for the defense and the same counts for the judges, is that we try to have as many public filings as possible to give all parties insights into what is exactly at play. And then I also want to emphasize that we've not stopped collecting evidence. Our investigations continue. So we're also still open to receive evidence, to still look into interviewing additional persons. Our core focus is, of course, at this moment on the confirmation of charges hearing against Mr. Duterte, but we also hope to continue other lines of inquiry, and we really hope to, well, continue collaborating with you on this. I'll leave it at that for now, and I'm happy to answer any questions afterwards. Thank you.
Thank you, Chantal. Now, may I call on Attorney Joel? What are the key legal and political challenges that the Duterte case faces at the ICC? Do you see any meaningful opportunities for accounting despite these hurdles? Attorney Joel.
Thank you, Doc Au. And good morning from the Philippines and good afternoon. Good morning from The Hague, I'm sorry. And good afternoon to our colleagues in the Philippines. And thank you to the CICC and the PCICC for pushing through with this webinar, notwithstanding the resetting of the confirmation of charges hearing. I will try to maximize the precious time that's allotted to me by diving right into the topic at hand. I will first discuss the current situation of the Duterte case from the point of view of the victims. Mr. Duterte has been in detention for a little over 6 months, and recently he has clamored for his release, alleging that his continuing detention while preliminary issues are being heard constitute injustice to him. But from the point of view of the victim's quest for justice, the following constitute the relevant timeline in the Duterte case that's before the ICC. First, it has been almost 10 years since the killing started nationwide in 2016 during Duterte's presidential term. It has been a longer 14 years and running since 2011 for the victims in Davao City who are also covered by the ICC jurisdiction. So it has been a decade or more that the victims have been waiting for justice for their loved ones. An overwhelming majority of the victims have been living without a breadwinner for 10 years or more, and the children who have been orphaned of one parent are now adults. Second, it has been almost 8 years since the Office of the Prosecutor opened a preliminary examination into the Philippine situation, way back in February 2018. Third, it has been 4 years since 2021 when the pre-trial chamber authorized a preliminary investigation in the Philippine situation. So if there's anyone who should complain about the pace of justice, it is the victims themselves and not Mr. Duterte. Also, from the point of view of the victims, here are what the defense has done in the short period of 6 months since Duterte's arrest in March of this year. First, the defense sought the disqualification of victims who do not possess passports or national IDs from becoming participants in the case. This could have resulted in the disqualification of an overwhelming majority of the victims. The pretrial chamber thankfully denied the defense request and upheld the acceptance of a whole range of identification documents. Second, the defense has sought the disqualification of the pretrial chamber judges, and thankfully this has been denied. Third, the defense has sought the disqualification of the ICC itself from trying Mr. Duterte on grounds of lack of jurisdiction. This issue also remains pending as we speak. Fourth, the defense has sought the disqualification of the ICC prosecutor, and this issue also remains pending. Fifth, the defense has sought the virtual disqualification or exemption of Rodrigo Duterte from detention through its request for interim release, and this issue remains pending. Six, the defense has also sought the virtual disqualification or exemption of Duterte from being subjected to trial by invoking his mental unfitness. This issue also remains pending. Seventh, and most recently, the defense has even sought to disqualify me and Attorney Cristina Conti from being appointed as members of the Common Legal Representative for the victims team. This issue remains pending as the PTC has yet to appoint the permanent LRV. And eighth, in his recent filings on the issue of Duterte's fitness to face trial, Mr. Kaufman has used words insinuating that the ICC registry has exhibited bias in its handling of medical experts who sought to examine Mr. Duterte's mental fitness. I wouldn't be surprised if he will eventually formalize his issue of bias against the registry by filing inhibition or disqualification down the line. At the rate that he is going, the only personality that Mr. Duterte has not sought to disqualify is his defense counsel himself, Mr. Nicholas Kaufman. So Mr. Kaufman should not rest easy because he might be next in the disqualification firing line. Now, with respect to the challenges faced by the victims, I would like to highlight at least two issues that greatly impact the victims. The first big challenge that the victims face is the issue on the scope of charges or the potential limitation of the charges. For the presidential period alone, from 2016 to 2019, there were as many as 30,000 who were extrajudicially killed during the drug war, or at least 6,000 police operation deaths as admitted by the Philippine National Police itself. There were also more than 400,000 who were falsely imprisoned or illegally arrested. There were cases of torture, sexual violence, disappearances, and victims of other inhumane acts, which all amount to crime against humanity within the ICC jurisdiction. In its application for a warrant of arrest, the OTP originally charged crime against humanity of murder, torture, and sexual violence, but the pretrial chamber only approved crime against humanity of murder related to 43 incidents. We have not seen at this point the documents containing charges, the DCC, so we do not know for sure if the charges have been expanded. But from all indications and reading from the redacted submissions, it is most likely that the DCC will only be limited to crime against humanity of murder. If the crime charged is crime against humanity of murder only, it will extremely limit the number of victims who will be allowed to participate and seek reparations later on. Let's remember that the biggest number of victims of the drug war are those who were falsely imprisoned and illegally arrested, who number almost 500,000. In fact, if the PTC rules that only the victims of the murder incidents cited in the charges are the only ones who can participate in the trial, the quest for justice may ring hollow for an overwhelming majority of the many victims. The conviction and imposition of penalties against Duterte is only half of what justice means for the victims. The other half of their search for justice is their quest for the recognition of the crimes committed against their loved ones, which will not be attained if they are disallowed from becoming victim participants in the trial. Having said all this, I wish to clarify that we recognize the many constraints and challenges faced by the OTP on the expansion of the charges, and we are thankful for the efforts of the OTP that have led to the arrest of Mr. Duterte so far, and for parrying off the multiple attempts of the defense to throw a monkey wrench on the case. However, we hope that the OTP considers in the decisions it makes that the ICC trial is the one and only chance of the drug war victims to obtain justice against Mr. Duterte and his co-conspirators. With the statement of Justice Secretary Remulla that the Philippines is unable to do domestic prosecution because crucial evidence were destroyed, the victims who will be excluded from participating in the ICC trial will have no way of pursuing justice domestically in the Philippines now or anytime in the future. And with the continuing strength of Duterte supporters in the Philippines, victims will be afraid to file cases in the Philippines. The second challenge that bedevils victims and potential witnesses are the multiple what-if questions in their minds. These what-if questions include the following. First, what if Duterte is granted interim release? Second, what if the case is dismissed for lack of ICC jurisdiction? Third, what if Duterte is rendered unfit to face trial and the case is dismissed? Fourth, what if Duterte supporters harass or commit violence against victims who participate in the ICC and the witnesses, potential witnesses? And fifth, the biggest what if question that really bothers many of the victims is, what if Vice President Sara Duterte becomes president in 2028? All these what if questions cause retraumatization to many victims. These questions that are up in the air have great impact on the victim's willingness to participate in the pre-trial and eventual trial. The sooner that the ICC can resolve many of these what-if questions to the satisfaction of victims, of course, the better for the quest for justice. The ICC and the OTP included should be wary of the possibility that these what-if questions are exploited for political purposes by certain forces in the Duterte camp. They are used either to rally supporters, especially in their efforts to regain power in 2028, or to instill fear in the hearts of victims and potential witnesses with the aim of discouraging them from participating in the ICC proceedings. But outside of the what-if questions that can be resolved by the ICC itself, the biggest what-if question, as I've said, that really affect affects the victims is the possible return of the Dutertes in 2028. This is a political question that's up for decision by the Filipino people, but it affects the ICC case because it engenders fear in the hearts and minds of victims and potential witnesses. I have personally heard of victims articulating their hesitancy to participate in the ICC proceedings because of this stark possibility in 2028. It's obvious that Duterte supporters are milking the Duterte case in the ICC for all the political dividends that it can generate in terms of solidifying and gaining more supporters for the Dutertes in the 2028 presidential elections. All of these bring him home campaign do not have judicial objectives among those who lead this campaign because obviously they know that it will in no way affect or influence the ICC. However, these kinds of campaign are effective tools to manipulate sentiments among Duterte supporters in order to sustain support for the Dutertes in 2028. And this brings me to my last point, which is the opportunity that the Duterte trial brings. There are many Duterte supporters who blindly support Rodrigo Duterte because they do not know the gory and evil details of how he implemented the drug war, how the victims died, and how their families suffered and continue to suffer to this day. The Duterte trial in the ICC will be an opportunity for the public to know the details of the many evil deeds that Duterte and his co-perpetrators committed against defenseless Filipinos. We understand that the ICC insulates itself from its proceedings from politics, but we hope that the ICC and the OTP will be conscious of any attempt to abuse reduction of details of the crimes and to turn its proceedings to further political ends. An attempt to adulterate or temper the evils that were committed during the drug war in the eyes of the public may potentially be part of a political agenda to keep Duterte's image untarnished before his adoring followers. The ICC and the OTP should be wary of the possibility that there could be non-judicial objectives in how parties participate in its proceedings. The Philippines went through the most violent, the most evil period of its contemporary history during the drug war, making the perpetrators liable in the ICC as well as allowing the world to know the details of the crimes against humanity committed by evil people during the very dark period of Philippine history will go a long way in helping the ICC attain its reason for being, fighting and preventing crimes against humanity, war crimes, genocide, aggression that continue to proliferate throughout the world. Thank you.
Thank you, Attorney Joel. May I ask Nimia to maybe share a little bit more about some of the views and comments of the victims in relation to the mandate of the ICC as well as the ongoing case?
Thank you very much, and good day to everyone for this opportunity to share the views and concerns of the families and victims of the drug war under former President Rodrigo Duterte. For a start, let me just share a background of the Philippine Human Rights Information Center and how we are able to come up with this information regarding families. The Philippine Human Rights Information Center, or PhilRights, is a research and documentation institute of the Philippine Alliance of Human Rights Advocates, or PARA. And since 2017, it has embarked on a comprehensive documentation activity, particularly targeting victims of extrajudicial killings under the so-called war on drugs. And that's the reason why, since 2017, PhilRights has been able to annually release a documentation report, except maybe during the period or during the height of the COVID-19 pandemic. The annual documentation report being released by PhilRights, which you can access through the PhilRights website, focuses on several important aspects or components of the drug war. One would be socio-demographic profile of the victims of EJK, circumstances of the killings like alleged perpetrators, manner of how killings were done. It also focuses on human rights violations perpetrated by duty bearers, implications of the human rights violations on families left behind, including children, wives, mothers, siblings, and the community. Now, my presentation is going to focus on two areas. One would be the general views and sentiments of the victims of the drug war on the postponement of the confirmation of charges hearing recently. And then second would be concrete actions being taken by the families in collaboration with human rights NGOs in the pursuit of justice. Now, when the postponement of the hearing of confirmation of charges was announced, the general sentiment of the families left behind was that of disappointment. And I think that is very understandable, considering that they have been looking forward to this very important event. Many of the victims, they say that the disappointment emanates from the following. Many of the victims are old, sick, and quite a number of them already died. In fact, 2 of the documented cases of Phil rights just recently died. And although they have participated in filling out of the individual or household application forms given by the OPVRS. Also, the disappointment emanates because they have been looking forward to this date since the arrest of former President Rodrigo Duterte in March of 2025, and are apprehensive that this development might lead to his temporary release. They do not believe in the reason given by the defense of former Duterte, who has asserted that he is unfit to stand trial due to his physical and mental state. And their apprehension or their position that he is really fit to stand trial, it emanates from the fact that the statements of family members would say otherwise, as evidenced by the statements released by family members in the media. Also, many victims are asking what guarantee they have that the hearing on the confirmation of charges date will not be postponed again. Now, despite these apprehensions and concerns, families have remained hopeful that eventually justice will soon come through the ICC because the domestic legal remedies in the Philippines are not that encouraging. So currently, the victims continue to actively participate in activities and processes in the country coordinated by various human rights NGOs like PARA and Phil Rights. And this include the following. First is the participation in education and training activities or sessions in the of HR NGOs on human rights and the ICC. So this includes holding of forums, release of information and education materials on the ICC. Also, they are reaching out to other victims and convincing them to have their experiences on the drug war documented. We have had quite a number of women, primarily women victims, who have actively participated in going to the communities to convince co-victims for them to be interviewed and to share their narratives regarding the drug war. Also, they are participating in the filling out of the OVPRS individual and household application forms to participate and for reparation. So that particular activity is continuously being conducted by the various human rights NGOs so that hopefully when the trial starts, we will have quite a substantial number of forms filled out. Also, they are actively involved in media events, forums, and mass mobilizations on human rights issues in the country. They have also filed complaints on human rights violations experienced by the victims to the Philippine Commission on Human Rights. Participation in human rights-related lobby work in the country, and this would include lobby work in the Philippine Congress for the passage of the Human Rights Defenders Protection Bill, and campaign for the Philippines to rejoin the International Criminal Court. And last, also, they are involved in international solidarity work. We have had the opportunity to send families or women in the international community to share their experiences and to solicit support from the international community, including the United Nations Human Rights Council. And lastly, they are organizing themselves into human rights formations in their communities. In other words, they have been able to overcome their fear, their passivity, and have declared themselves to be human rights defenders in their communities, particularly in their respective communities. So that will be all. Thank you very much for listening.
Thank you, Nimia, for that presentation. And we have one question from our participants here, from Professor Megumi Ochi from Ritsumeikan University in Japan. So her question is for Chantal. I would appreciate it if you could talk a bit about if there is any possibility to get back sexual crimes into the charges.
Thank you very much for that question. At this moment, I can't comment yet on the crimes that are indicated in the document containing the charges, as there is no publicly redacted version yet. What I can indicate is that throughout our investigations, we've been seeking to add as many crimes as possible and allocate resources to investigate the wider range of crimes that has been committed against victims, against families, against the wider community in the Philippines. This is also what was being reflected in our arrest warrant application. Clearly, the judges didn't agree upon all of the charges that we alleged Mr. Duterte of. Will we be able to add even after a confirmation of charges hearing? I don't think so. But that doesn't mean that this wider range of crimes is not being reflected in the contextual elements that we describe. It's a discussion that we've been having quite often, and I really understand also the issues that Joel has been brought forward about families not feeling acknowledged, not feeling recognized for the hurt that has been caused and the full spectrum of crimes. What we are doing and have been doing as Office of the Prosecutor is at least try to reflect geographically, but also types of crime-wise, as much as possible, the wider variety of crimes that have been committed throughout the Philippines. So not just Mindanao, not just the presidential period, but we have to focus at some moment. So again, I can't go exactly into the details of what is in the document containing the charges, but do please know that we are trying to add whatever we can, or we have sought to add whatever we could, but certain hard decisions also had to be made. So even if crimes are not being charged individually, we have sought to at least reflect them in the wider case that we're trying to bring, and also our investigations continue. Thank you.
Thank you very much, Chantal, for the response to the issues raised by Joel and the professor. So thank you, Chantal and Joel, as well as Nimia, for this session. If you can stay, maybe if there would be time, there might be questions that will be raised to you, but we now have to go to session 2, which will be moderated by Nour.
Thank you, Dr. Aurora. Hello, everyone, again. So we're now going to turn to our next session, which will focus on a victim-centered approach to the Duterte case. My first question, we will start with Maria Julia from VPRS. So first, thank you for being with us today. Can you please tell us a little bit about the role of VPRS in the present stage of the proceedings and maybe beyond?
Thank you very much for your question, Nour, and thank you very much for having us today. We really appreciate the space and having all of the participants connected here today. Sure. I would like to think about the VPRS as a two-way street. So we provide assistance to the judges in matters relating to victims' rights, but we also inform victims of the rights that they have before the VPRS, and before the court, and how to exercise these rights. So I think that the most relevant right at this moment in the present stage of the Duterte case is the right to participate in the proceedings. So the VPRS, we are in charge of preparing the process for allowing victims to exercise the right to participate. We create and we draft tailored application forms to facilitate this application process. At the present time, for the confirmation of charges hearing, we prepared 2 forms, an individual form and a household form, as it has already been mentioned. And we provided informative sessions for groups of victims and survivors, and also for the organizations supporting victims and survivors, so they can make an informed decision whether they want to participate, whether they want to apply for participation in reparations at this present stage. And after we provide these informative sessions, victims apply, they complete these application forms, and then here at the VPRS, we receive these application forms. For the present process, for the confirmation of charges hearing, between July and August, the VPRS we registered a total of 322 application forms. Out of these, 18 applications were only for reparations. And I will talk a little bit about the reparations in a second, and I'll also let Francisca talk more in detail about this process. But out of the 304 application forms that were assessed by the VPRS, were for participation in the pretrial proceedings. As was also mentioned before, this doesn't mean that victims will not have more time to complete application forms. And at the moment, we had a deadline for the 3rd of August to receive the application forms. And all of the application forms that we receive after this deadline of 3 of August, we will keep here at the VPRS in our secure database, and they will be analyzed after the confirmation of charges hearing, and if we go into trial stage. This process of the application for participation in reparations in the Duterte case goes a little bit like that. We inform victims of their rights. We do these informative sessions. We share our key messages, so victims can make their informed decision whether they want to apply for participation in reparations. Then we have a deadline, a judicial deadline, to receive the application forms, and this we do because we need to transmit them to the judges. So we need time to analyze each individual application form. We need time to make the recommendation that we make for the judges. And then we present this application for the judges with a report. The VPRS was ordered by the judges to implement what we called the ABC approach. So this means that from the applications we received when we analyzed this, Group A applications are the ones are deemed to be or considered completely within the scope of the case. Then we have Group B applications that are the ones considered to be outside of the scope of the case. But then we have the Group C application forms that are the ones that are borderline, or that the VPRS was not able to make a recommendation on that. So the judges are the ones that have to make a decision on all of these application forms that we receive. From the application forms that we received, the VPRS assessed 15 applications as Group A. We assessed 10 applications as Group B, and the VPR sent a sample of 10 applications assessed as falling within Group C, for the chamber to determine whether they accept these application forms. When the chamber make a decision on the participation of these applications, they will also make a decision on the common legal representative of victims. This is another right that victims have, to be represented by a legal representative. And the VPRS, in the context of the Duterte case, we were also in charge and mandated to do a consultation process. And during this consultation process, the VPRS or the registry was mandated to make a report for the judges on the legal representation of victims, on the information collected, and recommendations on the way forward. So this was also submitted to the judges for their consideration. And as it hasn't been mentioned before, we are still waiting for a decision in this regard. So in broad terms, this is the role of the VPRS and a little bit of the work that we've been doing here in the Duterte case in the present stage of the proceedings. Of course, we're also in communication with victims and survivors, with the organizations, and also we try to transmit all of this information in a manner that is accessible for victims and survivors at this point. We also have the victims information in the website of the ICC, where we try to keep updated. We try to submit updated key messages for victims and survivors to access and to be informed a little bit of this process. I don't want to take more of the time, so maybe I will conclude my intervention here. Thank you so much.
Thank you so much, Maria Julia. That was incredibly valuable. So thank you for your work and for your intervention today. I will now move on to Francisca. Francisca, if you could please elaborate on the role of the Trust Fund for Victims in the context of the Duterte case, both in terms of potential future reparations following a potential conviction, and/or any current or planned assistance to victims under the TFV's assistance mandate. Thank you.
Yes, good morning and good afternoon. Thank you so much, Nour, for having the Trust Fund for Victims at this session. I'm the legal advisor of the Trust Fund for Victims and happy to give you a short overview of our work and put that in context of the Duterte case. Basically, the Trust Fund for Victims is part of the court's reparative justice system, very much linked to the court, but it has its own board of directors that is working pro bono and selected by the Assembly of States parties. 5 members representing the 5 regions of the world. At the moment, our chair is from Estonia, so from the Eastern European region. Then the Trust Fund has a secretariat led by the executive director. We are a bit more than 30 staff members, half of us here in The Hague, half of us in the different country offices of the ICC, in order to oversee and run the programs of the Trust Fund for Victims. And there I come to the main task of the Trust Fund for Victims. It is to implement reparation programs for victims of convicted persons, convicted by the ICC, and these programs are run on the basis of a reparation order that is issued by the ICC. How does that work? There has to be first a conviction, and only if there is a conviction, then the chamber will call for reparation proceedings. Only last week, for example, we had a hearing in the Al Hassan case as part of these reparation proceedings. The victims and their legal representatives become a party to the proceedings. They can then also appeal the result of these proceedings, the reparations order. And the trust fund is participating in these proceedings as an expert, advising on the situation in the country, making sure the voices of the victims are heard to the degree possible. The trust fund also sees itself as having a role in advocating for the plight of victims in these proceedings. As a result of these proceedings, there is a reparation order, and this reparation order is against the convicted person, for the victims of this convicted person. It basically determines the modalities of reparation. It determines whether there will be compensation, whether there will be a rehabilitation program, symbolic measures, satisfaction measures. That is what the judges determine, and the determination is against the convicted person. Now, it is therefore also the convicted person that needs to make available the funds for reparations in the very first place. However, if there is no such funding from the convicted person, as in the current previous 5 cases, it was the case, then the trust fund can step in with funding it has received from states and private donors. That is what we call complementing the reparations order. And I would like to underline that enforcing reparation orders and making sure there is funding from the convicted person, that is not the task of the trust fund. That is the task of the court, of chambers, and then later the enforcement of the presidency of the ICC. They're in charge of that. So that, I think, is very important. Once there is a reparation order and reparations are ordered through the trust fund, then the trust fund can it's not against the trust fund, it's through the trust fund, then the trust fund can put in place a program, develop a draft implementation plan, have that approved by the board of directors looking at the finances of the trust fund, and by the chamber, saying, is that in line with the reparation orders and the principles that we have established? And then, once that is approved, the trust fund can start the implementation. To date, the trust fund has already completed one reparation program in the case of Katanga, who was ordered reparations at a value of $1 million for about 300 victims. And we are in the process of coming to an end in the cases of former child soldiers in Ituri, in the case Lubanga and Taganda, as well as in the case of Al-Mahdi. Their mausoleums were destroyed in Timbuktu. Ongoing and also in the conception phase are basically programs for the case of Ongwen, and at the stage of a reparation order I just mentioned is the case of Al-Hassan. But there was also recently another conviction in the Central African Republic, so we expect that these reparation proceedings will start soon. There is another role of the trust fund as well, that is to the trust fund can decide with its own funds from states and private donors, so to say, to run programs for the benefit of victims in situation countries, but only for victims of ICC crimes. So it has to be at that level. And it has to be also, in a way, it's not completely connected to a case before the court as a role, these programs. So We have been running such programs in 7 countries since 2008. So that some of the programs have been finished at the moment. They have completed. We stopped them, and at the moment our focus is very much on reparation programs. But at the same time, the board has also determined that the trust fund should look into all other situations, including the Philippines, but including also all the other situations, whether or not one can run a program there. However, there has to be clarity about scopes and funding availability. The most recent reparation order of the ICC ordered 52.4 million against Mr. Ongwen, million euro against Mr. Ongwen, and the Trust Fund for Victims got 5.7 million last year in terms of voluntary contribution. So there is a bit of a gap in terms of need, in terms of financing. So it's therefore really important for the trust fund also to follow through with its third role, that is raising funds from states and from private donors. I conclude here because we have little time. I hope that has given you a good overview, and also in your minds, at least, you can connect it to the Duterte case. But I'm happy to answer any questions. Thank you.
Thank you so much for that and for highlighting the work and the processes of the trust fund, but also at the same time drawing parallels with other situations, which is always really important to hear. So thank you so much for your intervention. I will now move on to Benji. Hi, Benji. So my question for you is, given Redress's work on the impact of disinformation on the Duterte case, how do you see current disinformation campaigns, such as those on social media, for example, affecting victims' ability to safely engage and participate in proceedings? And maybe you can also give us a few examples of these false claims.
Thank you, Noor. Good morning from those of us in The Hague, and good afternoon, magandang hapon, to those who are connecting from the Philippines. In talking about the current state of disinformation on social media, I wanted to give you context and share with you first some of the more salient points from a focus group discussion that was held last week and was conducted with one of the survivor groups in the Philippines. The main findings are that essentially the latest developments in the case in the ICC are fueling disinformation and are causing more victims to become more anxious than they already are. The first is that the fact that there is still no public document containing the charges caused confusion among victims, causing many of them not to apply for participation. The fact that there was a last-minute postponement of the confirmation of charges hearing caused victims to think that the case against Duterte is weak. These two things taken together create doubts in the minds of the victims about the viability and the substance of the case. And the organized disinformation mechanisms is then able to capitalize on these doubts to create even more fear and doubt in the victims. Simply put, there are times when the court itself gives fuel to the disinformation campaign that then affects the victim's perception and eventually their decision to participate. It also does not help that the disinformation mechanism can be very creative in twisting whatever news comes out of the court. I also want to build on Joel Butuyan's points earlier. Toward the end of his intervention, he listed the big what ifs that remain in the victims. I wouldn't repeat them, but so many of these what ifs are questions that could have been resolved by the ICC. And the court could put an end to these what ifs by issuing prompt rulings or orders. But for various reasons, they have not been doing that. And actually, it is these what ifs that are giving fuel to the disinformation campaigns. So that is the state of the current disinformation landscape in the Philippines. They are very creative, and they have so much material to latch onto and to use because of the uncertainties and because of the questions that remain pending before the court and also remain unresolved. Now, this brings me to another point. Some examples of the disinformation. You have heard from Joel that there is a fear that the daughter of the president might be elected as president. And one of the disinformation or one of the fake news around that is they are saying that if the daughter of Duterte, essentially the current Vice President Sara Duterte, is elected as president, she could negotiate the release of Duterte, or she could actually put an end to the case. Of course, we know that's not true, but people believe that, and it's in layers because this can also be a narrative to further the political ambition of Sara Duterte. If people believe that and they want Duterte out, they might just actually elect her. Another fake news that I think was dangerous is that people who are applying for participation, victims who are applying for participation, will have their names revealed to the defense. Essentially, the Dutertes will know what their names are and where they come from, and that gives them a sense of fear that would also make them doubt whether or not they will choose to participate. Nour, you didn't ask me this question, but I wanted to extend this a bit and talk about how international NGOs can help fight disinformation and help support victims. And I'm coming from a perspective where I worked in the Philippines. I have been working in the Philippines since 2018 on the ground, documenting cases, not just of these killings, but also of rape, of disappearances, of torture, and now working here in The Hague, closer to the International Criminal Court. I know for a fact that local organizations in the Philippines might lack access to information that organizations in The Hague may have easy access to. International organizations have both the proximity to the institutions and the expertise from working with or inside these institutions and are best placed to respond to disinformation and give accurate information, and even have a quick response to provide accurate information. And this can be done through resources such as the ones that have been released by Redress, tackling the disinformation around Duterte's case, which is available in English, Filipino, and Cebuano. I will be pasting the link later on our chat of how you can access these kinds of resources. But this is one of the ways that INGOs can help. I won't be taking more time. If there are any questions, I'd be happy to answer them. Thank you.
Thank you so much, Benji, for that important intervention, also for shedding light on how disinformation is really affecting victims' ability to participate safely. And we also appreciate Redress's vital work in this area, and understand that there's so much more that we can do on fake news. So thank you for that, Benji. Daniel, good morning, good afternoon to you. My question for you is, how does the limited scope of the charges in the Duterte case really affect the ability of victims, especially those whose experiences may fall outside of the defined charges, to participate meaningfully in the ICC proceedings? And maybe you can focus a little bit on gender crimes. Thank you.
Hi, good morning, good afternoon, good evening. Thank you, Nour, so much for hosting this webinar and inviting FIDH. This is a really, historic case and situation. And for FIDH, we have over 180 member organizations around the world, and very importantly, our member in the Philippines, the Philippine Alliance of Human Rights Advocates, PHRA. We were very, very disappointed to have to, cancel the events of this week and the postponement of the confirmation of charges hearing. That said, hearing everything today and learning more today gives us all a lot of inspiration and looking ahead. But I think what's important about today is again centering victims and survivors. That's what we are trying to do every day in these discussions, and to make sure that whatever happens is meaningful and that people feel heard and part of these proceedings. As Joel already explained quite a bit of what I was going to say, and others, the scope of the charges I can't express it more, it's so central, as we know. The confirmation process will really, for a lot of people, determine which harm is recognized and who will participate and ultimately receive or seek and potentially seek reparations. And right now, with such a narrow set of charges, everyone is hoping and trying to think how this can be expanded, and if not, what that means, and what other kind of avenues there are for people when we hear of the scope of the actual crimes and number of victims and survivors. And I also wanted to touch, as was mentioned, on particularly the track record at the ICC on gender-based crimes, because unfortunately for many of us who've been working at the court or supporting the court for many years, this is perhaps illustrative of a broader challenge that the court faces. So it's very important right now in terms of, we don't see the DCC. We don't know what's going to happen. And what we've heard today, it doesn't give me personally a lot of hope that they will be expanded, even though that is very possible technically throughout the proceedings. And I'll touch upon that. But right now, for victims, that have suffered rape and torture, that means they cannot be considered victims of the case as of now. And it's also the narrative more broadly. This, we only see the reflection of the killings, and for many, this is a really distorted image or picture of the broader level of violence, and even for some or many. It feels like an erasure of their experience, which we heard today. And we can't stress enough that the lack of access to eventual reparations would be devastating for many. So I did want to very briefly go through the stages, because I am talking to a lot of people throughout the last few weeks, even though it might not happen historically or in the court's jurisprudence, it has happened that charges evolve. And for some, it might seem that the document or the arrest warrant is the final say, but in fact, that is only the first step, and the judges had a very low threshold to decide if there was a reasonable grounds to believe that Duterte committed crimes, and it's pretty low. But I would say, a far less extensive look also at what materials the prosecution submitted. But if it does stay there, we've seen in the past, for example, in the DRC situation and Taganda case, that which was only covering child soldier crimes. In that case, for example, a second warrant was issued. So that's another way that things can evolve, which really expanded the crimes against humanity and war crimes to include rape and sexual slavery and other crimes. So we saw second arrest warrants coming in. That's one way. And then, of course, the DCC, the document containing the charges, which has to be filed or has been filed, and it just has to be publicized. It can expand or refine the case, specifying incidents, as we heard already from the OTP, locations, dates, modes of liability. It's really, really key. This document, I think, will be the document to look at. But just to say, there is an example, for example, in the Ongwen case, in the Uganda situation, the warrant was really limited, and this is an unusual example, but the DCC expanded to 70 counts, and it included then sexual violence, forced marriage, forced pregnancy, rape, and sexual slavery. So it's not unheard of. But what is needed to get there, of course, is the necessary potential evidence and testimony. And if that message from the pretrial chamber is not looking good, then we won't see that necessarily. Then and there's other moments when the charges can be, even after the confirmation of charges hearing, and of course some of the charges might be confirmed, others not. But even before the trial, there can be amendments with permission, again, rare, but just to say, and then throughout the proceedings, and even afterwards, the chamber can the trial chamber can recharacterize some of the facts in terms of motive liability. I just wanted to highlight that flexibility, that it's there, but it depends on the, of course, strength of evidence and the OTP strategy. And I'm not at all criticizing the OTP. We don't know, we don't have enough information, and we definitely are very supportive of this investigation. But there is a strategy, and they will be making decisions. So it's great to always try to, I guess, encourage and to really promote that the fullest, broadest scope of charges are included in the DCC. Sorry, just a sec. And just to highlight now briefly the gender-based crimes, now we have the new acronym GBCs, have really faced systemic hurdles at the court. It's getting a lot better, but in the early years, under-investigated, undercharging, difficulties in meeting the evidentiary thresholds, and fragile modes of liability. And NGOs like Women's Initiatives for Gender Justice and FIDH, we've been working for years and years, urging the court to prioritize these crimes in charging decisions, and to really adopt now even more and more intersectional and trauma-informed approaches to really show the full extent and scope and experiences of survivors. So the undercharging, as I already mentioned, happened in Ongwen and Taganda, and then that was remedied. There's been a lot of, and still is, evidentiary challenges because this type of evidence, as we know, there is a lot of stigma and trauma and security risks for victims. So survivors still to this day are often reluctant to testify. And corroboration, if that's needed, but it technically isn't needed, can be difficult and lead to cautious charging for the prosecution. And we just saw in the Al-Hassan verdict judgment that even though the majority of judges found that Al-Hassan had participated in committing gender-based crimes with intent and knowledge, these findings didn't lead to convictions. And now we're seeing in the reparations stage what that will mean for those victims. But of course, many will be excluded because you need to have been a victim of the crimes that were convicted. I mean, there's of course there's collective reparations, etc. But just to say that does impact and the narrative and the entire way that the case is viewed now. So I think the big lesson is that unless these types of crimes are included from the outset and confirmed, survivors really risk not only not participating, but also not getting reparations and just being excluded from the official record of the case. And it really highlights why strong investigations and early attention to these issues are so important. And also, I think we need to look very closely at the judges and their background and their training. So just going to end with civil society's role. And we know, because many of us here are from civil society, but just to stress how important, the role of supporting documentation of these crimes, but having very good training on sexual, on gender-based crimes and do no harm, and knowing how to do that in a really comprehensive, effective way. I want to highlight outreach because without very strong outreach from the outset, from the ICC, from the registry in particular, there's a lot of people that it won't know about this investigation, won't know to come forward. And if they are more aware and more people are aware, the evidence will be stronger, the testimony potentially will be stronger, which would potentially have, then the prosecution would have a better chance at going forward with these charges. And I wanted to touch on that, the judicial aspect. I think we really need to focus on judges. I mean, in Canada, where I'm from, there's a judge school every year that judges have to participate in and learn about contemporary issues like this. And I'm going to be frank, I don't think we're there yet at the ICC on many issues, especially gender, intersectionality, looking at how to really look at these issues in an effective way and to be consistent. We see the practice is really inconsistent. And then my last line would just be that NGOs like FIDH and many others here are looking at, of course, other avenues for justice, because we need to always remember this is a court of last resort, and the vast majority of cases need to be investigated and prosecuted at the national level. Of course, when that can't happen in the Philippines, we have extraterritorial and universal jurisdiction, which is literally exploding across the world. And we're very excited about projects in all regions of the world now to expand networks and to enhance cooperation with NGOs and prosecution authorities, so that when people travel, when survivors are in other countries, that cases can evolve there too. I'll leave it at that. Thanks.
Thank you so much, Dania, for your very insightful intervention, for also echoing the impact of the limited scope of charges, particularly on gender-based crimes. It's crucial and often an overlooked issue. It was also really good to hear that, charges can evolve, such as in the DRC situation and in others. And I'm sure this provides hope to many. So thank you for that. We will take one question from the chat before moving on to our last session. And that question is for you, Maria Julia. It is from Megumi Ochi. They are asking, have any VPRS staff actually come to the Philippines to help victims to conduct individual application to reparation in hands-on manner, just like in Uganda? Or maybe the situation in this country is different.
Thank you very much, Professor, for your question. For us at the VPRS, number one priority is always the security and well-being of victims and survivors. So we always prioritize this, and we try to find creative avenues and approaches that allow victims to exercise their rights in a secure manner that is also meaningful for them. So at the moment in the Philippines, what we usually do is we do a security assessment to make sure that we're not exposing anyone. Again, priority is security and safety and well-being in general of victims and survivors. If this means that us, the VPRS, traveling to the Philippines, exposing victims and survivors, then we choose not to. We choose to explore different options. We have very close collaboration and coordination with local human rights organizations, and we try to explore different options that are safer and that will deem that the victims and survivors will be safer. Of course, in other situations, as the one that you mentioned in Uganda, we have been working there for many, many years, and the security assessments are a bit more flexible in the sense that our engagement with victims and survivors can be done in a more safe and secure and more controlled environment. So at the present time, we have not been in person in the Philippines. We have not been doing the collection of the information ourselves, BPRS staff in the Philippines. We have been trying to come up with creative ways of also allowing victims and survivors to have access to their rights, but in a safer manner. We have also been working on developing different strategies. For example, we have been working in developing an online application form through Cobble Toolbox, so the information can flow directly online to the VPRS, and we're trying to enhance those cyber security and information protection. But in short, the answer is no, the VPRS has not been in person in the Philippines at this moment due to security concerns.
Thank you so much for your response. And I'm also flagging that there was also another question that Francisca kindly answered in the chat. So we will now move on to our last session, and I believe we may go 5 minutes over time if that's okay with everyone. So the third session is the role of activists and grassroots movements and the challenges that human rights defenders face in the Philippines and worldwide. Colleen, my first question is to you. So first of all, thank you for joining us today. What role do grassroots organizations and activists in the Philippines play in advocating for justice in the Duterte case? And how can their efforts be supported, be protected, especially in the context of, ongoing threats, stigma, and disinformation that we spoke about earlier. And if you could also please just provide us with some examples that you see from the ground. Thank you.
Thank you, Noor, and good day to everyone. Again, I'm Colleen. I'm the Executive Director of Ateneo Human Rights Center, or HRC. We're an organization that promotes and protects human rights, and we are based in the Law School of Ateneo de Manila University in the Philippines. We are also the Secretariat of the Philippine Coalition for the ICC, and in this role, we have facilitated the submission of victim applications as regards to the Duterte case. And of course, thank you to the coalition for putting together this webinar and pushing through despite the developments in the confirmation hearing. To share about this, the role of activists, law students, and grassroots movements, I would be remiss if I don't share a few examples and stories from the ground. I recall that when Mr. Duterte was arrested in March this year, I went to Silingan Coffee Shop, a coffee shop managed and run by widows, to the drug war. And I was there to meet a friend and to join the gathering. And I will share my screen to show two photos. This is a birthday cake. And the birthday cake reads, Hakbang sa Pananagutan. This is Tagalog or Filipino for step towards accountability. My friend, she is a human rights lawyer, but she's also a victim who lost her brother to the war on drugs in 2016 and had filed cases here in the Philippines. In that gathering, we listened to several mothers and some activists, including a well-known photojournalist, that we talked about how despite Duterte supporters, and a lot of them are even neighbors of victims, would harass the mothers and the widows or malign them for cheering for Duterte's so-called kidnapping. The mothers, the widows, and the activists present emphasized how this moment of justice, the arrest at that time, belongs to them, to the mothers who lost their sons or wives, who lost their partners. My friend, we recall saying how this moment was made possible only together, through communities of widows, artists, lawyers, other human rights groups and activists, journalists, and a whole lot more whose names we do not know. This was true, although so was the feeling of incompleteness or of unrest. One of the mothers then said and asked, why does it not feel complete? At that time, we were trying to figure out where this feeling was coming from. And my friend and I recalled how 9 years ago, we would be visiting families undercover, documenting, taking witness statements, and how taking witness statements would mean gathering all the resources of small organizations, have either to rent a secure vehicle to ask for a security detail, even if that was possible, even and if this was not possible, we would do it ourselves, of course, and this meant hiking around there was also a time where she shared that she would document around 5 to 10 cases of killings every day, which was beyond her pay grade at that time. This also reminds me of a nun. I would call her, and this is not her real name, I would call her Sister Nancy. She would visit every funeral, then constantly on the lookout for police officers who were also visiting the same funeral. She had asked she had asked me during my first week at work if I knew how to pray for the dead through song. Fast forward to around 2021 to 2022, at around the time that the preliminary investigation was authorized, and in 2022, where the government had sought for deferral of the case, a community member, I'll call him George, he told me that when he thinks of justice for his brother, he thinks that this meant that if their story was written in history, he would love for his brother to be known not by the way he was killed, but by the way he lived. And that honoring that life was enough to plod on, despite the actual threats and harassment experienced by communities. And another community leader, let's call her Marian, reminded her fellow widows and mothers who had been experiencing then being offered monetary consideration by police officers in exchange for the cases. She reminds them, we need to fight. We should not give in. And lastly, last story I would share is about one of AHRC student interns. He's a law student. Let's call him Andrew. He has been joining AHRC in most of its efforts to organize sessions with communities and together with other PCICC organizations to assist families in understanding the victim application process and in the preparation of the applications for the families. In one of our gatherings, we were missing a volunteer. And this meant pushing back much of the time that we had and the limited time that the families had at that day. Andrew, our intern, walks in the office with the only intention that day to study and to stay put. And I ask him if he's busy. He responds only with the question, what do we need to do? And he proceeds to interview an applicant to explain the process and the possible outcomes of the application. That batch completes their applications together in time for the VPRS's deadline in August, and in time for a post-debriefing activity conducted by one of our partners too, and no one was left behind. With these stories of the different activists, lawyers, human rights representatives, and law students who we shared today, we see how their roles are diverse and critical. As organizations, as activists, we are here to document, to bear witness, to organize, to continue to call for accountability. We also here to sound the alarm and to amplify the voices. We are here to provide expertise or services in whatever form or manner. We are here to test interventions that are available. We are here to continually study, to echo and communicate the truth, especially when information and access to information is limited or restrained. We are here to encourage when things get difficult or challenging. And we are here to be brave. And I feel that from all these stories, and these are, I guess, stories that will are shared also by a lot of those who are here with us today, whether here in the Philippines or here in the Netherlands. We understand that the role here is to show up and to ask what needs to be done, and to roll up our sleeves and to live to answer this question. We show up to make sure that every victim counts. We see here that in light of the postponements, the reflection really is, although justice feels uncertain, maybe we find it in the hope that we make and we find in each other. This can be always supported by continually pushing for victim-centered services and support, whether this is in the form of advocacy, campaign, financial support, to communities or to organizations that support victims. Lastly, I would share that we recall that there's a feeling that justice almost always feels unfinished or incomplete, but maybe because the humanity of a person who was killed can never be and should never be encapsulated or limited to one ruling, to one warrant, or to one judgment. We see here that activists, students, and grassroots communities are here not only to fight for the future of justice and accountability. We create moments of justice now as we continue to choose the role that we play and that we choose to play this well. And by doing so, we plod on, we address impunity, and we seek accountability from institutions. We give the dead their names back, and as we refuse the culture of death. And hopefully, in the things that we're able to do, we create a world where justice can live. So with this, I give the mic back to Nour. And I wish everyone a good day.
Thank you, Colleen. Thank you so much for your powerful intervention and for highlighting the critical role of grassroots organizations and advocacy, but also for the voices of mothers of victims in the fight for justice. Gilbert, we will now turn to you. My question for you is, what are some of the key challenges human rights defenders are currently facing globally in the Philippines, and how can the international community support, including institutions such as the ICC?
Thank you, Nour, for having me here, and also greetings to all our colleagues at magandang araw po. So I'd like to share a slide that I actually shared in the victim strategy last July that was sponsored by the Division of Judicial Services of the ICC Registry. And I'd like to encapsulate it as a form of summarizing the first portion of this webinar, which is about the ICC, the second portion, which is about the victims, and the third, which is about the other groups. And if I may share it now. I think this diamond of support encapsulates what we have been discussing in this webinar, because we want the ICC process to be victim-centered. In fact, it should be victim-centered, because international crimes, they're not victimless crimes. They're victims who have suffered harm, direct and indirect harm, as well as socio-economic harm. But at the same time, the victims need the support of other groups. And in this diamond of support, we have there the psychosocial support. These are the CSOs who directly intervene and directly help in the economic needs of the victims. Because in fact, if we remember the war on drugs, those who were actually victimized by the extrajudicial killings were the breadwinners of their respective families. So the long-term effect here is that there has been a socio-economic dislocation of the victims' families. In fact, some of them had to get out of their own communities because also of the social stigma that has come along with being tagged as a drug lord or a drug user. Hence, this is the challenge among the CSOs in the Philippines, which is actually to sustain the psychosocial support that they have provided and they are still providing for the victims. Because remember, children of war and drug victims need education. Families of war and drug victims, they need secure livelihoods. And in fact, with the challenge of the stigmatization that they have endured, there's really a psychosocial dislocation of victims' families. Hence, this psychosocial support is not just for 1 year, it's really until the children of the victims' families can actually finish their education. Hence, this is where other funders, INGOs, can really help. victims groups, and CSOs who help with the psychosocial support of victims. But I'd also like to point out that there are other support groups. What are these other support groups? These are CSOs or other networks which may not be directly helping victims, but they're actually helping in shaping the discourse with respect to international criminal justice. These are like the Duterte accountability networks. For example, the Filipino community here in the Netherlands, as well as in the larger part of Europe. How can they help? They can help in actually shaping the discourse, especially in the Philippines, because as Benji has stated earlier, there has been disinformation in the Philippines, especially with respect to the ICC proceedings. And these other support groups can actually help in actually focusing the ICC proceedings as well as the media and the society on the victims' rights under international law. We all know that the victims under international law, they have the right to justice, they have the right to access to justice, and they have the right to the truth. And when we say the right to the truth, this is a historical record of the victimization that they have endured during Duterte's war on drugs. Hence, how can these other support groups shape the discourse against disinformation? Let me try to give a specific example. During the arrest of Mr. Duterte and his eventual surrender to the ICC, there were really disinformation campaign that kawawa naman siya, pity him. But actually, drowned out in all of those discourse is the issue that the victims also have that right to justice and they have the right to go through these proceedings before the ICC. What else? There's also this disinformation that the for example, the ICC postponed because allegedly the case is weak against Mr. Duterte. This is also a disinformation because the postponement is really a show that the ICC proceedings really respects the right to a fair trial of the suspect, because the ICC is really also a court that actually embodies human rights. Hence, no one can really accuse the ICC of being partisan. No one can accuse the ICC of being a political institution because it only looks at the facts, the law, and the evidence. Hence, there's also a need to always remind society at large that the victims are an intrinsic part of these ICC proceedings, that the victims have the right to justice and the right to access to justice. Let me end with this note. We here in the CSO world, we have different roles to play. And eventually, hopefully, if the chamber will appoint the legal representative for victims, those legal representative for victims will be focused on the ICC proceedings, pre-trial chamber, hopefully to trial, and even to the reparation stage. And this is where the other support groups can come in, because this is where the other support groups can actually shape the dialogue, the discourse in the larger society, that we need to strengthen that ecosystem for international justice, and activists, students, grassroots organizations, human rights organizations can play a pivotal role in educating the larger society that the victims have the right to justice and they have the right to the truth. Thank you for your kind intervention.
Thank you, Gilbert, for that important intervention and for highlighting the Diamond of Support framework. It's a powerful reminder of how coordinated efforts between civil society and support networks are essential. So thank you for that. Everyone, we have come to the end of our webinar with a few minutes over time, but thank you so much for staying. I would like to thank all the panelists for your valuable insights and for shedding light on the pursuit of justice in the Duterte case. We're also very grateful to everyone who joined us today, all participants and everyone who made this happen. Yes, as I mentioned earlier, the webinar will be available for you to watch it offline later. Yes, please feel free to reach out with any further questions. I'm happy to put you in touch with our panelists. So once again, thank you so much. We hope this conversation continues beyond today. Thank you, everyone.